I never thought I'd end up in small claims court over a patch of ice. But that's exactly where Brenda Morrison dragged me on a freezing Tuesday morning in February 2025. The whole mess started 3 weeks earlier when I was sitting in my living room in Naperville, Illinois, watching the snow pile up outside my window. I'd moved into the Willowbrook Estates development 6 months prior, a decent neighborhood with modest 2-story homes and tree-lined streets. The place seemed perfect until I discovered that our HOA president, Brenda Morrison, treated the rulebook like it was the Constitution, and the 10 Commandments rolled into one. That particular morning, the meteorologists had predicted light flurries. Instead, we got 8 inches of heavy, wet snow that transformed the entire subdivision into a winter wonderland. I was supposed to meet my brother for lunch in Chicago, so I'd shoveled my driveway and the sidewalk directly in front of my house by 9 in the morning. My shoulders ached from the effort, but I'd done my duty according to the HOA guidelines, which stated homeowners had to clear their walks within 24 hours of snowfall. I threw the shovel back in the garage, climbed into my truck, and headed out for the day. I didn't think twice about it. When I got home around 6 that evening, there was a bright orange violation notice stuck to my front door. I pulled it off, squinting at it under my porch light. According to Brenda Morrison's flowing script, I had failed to properly maintain my property during inclement weather. The citation referenced Section 12, Paragraph 4 of the HOA covenant, which apparently required homeowners to keep their walks clear at all times during winter weather events. I stood there in the cold, reading the notice 3 times. I'd shoveled that morning. The sidewalk was clear. Sure, a light dusting had accumulated throughout the day, maybe half an inch at most, but calling that a violation seemed excessive even by HOA standards. The next morning, I found Brenda standing on my front lawn at 7:30, taking photographs with her phone. She was a woman in her late 40s with severely cut blonde hair and a permanent expression that suggested she'd just bitten into a lemon. She wore a puffy purple coat that made her look like a grape, and she didn't acknowledge me when I stepped out onto my porch. "Can I help you with something, Brenda?" She lowered her phone and fixed me with a look that could freeze water. "Just documenting continued violations, Quincy. Your sidewalk still hasn't been properly cleared." I glanced down at the walk. There was maybe an inch of fresh powder from overnight flurries. "I shoveled yesterday morning. This is new snow. The covenant is very clear. Sidewalks must remain clear during winter weather events. It's still snowing, which means it's still an event." She raised her phone again and took another photo. "Brenda, that's ridiculous. I can't stand out here with a shovel 24 hours a day. Then perhaps you should reconsider whether you're suited for this community." She tucked her phone into her pocket and pulled out a stack of papers. "I'm also here to inform you that you're being fined $250 for the initial violation, and an additional $100 for each day the violation continues." My jaw dropped. $350 for an inch of snow, for flagrant disregard of community standards. She handed me the papers and turned on her heel, marching back toward her house 2 doors down. I wanted to crumple the papers and throw them after her, but I knew that would only make things worse. Instead, I went inside, grabbed my shovel, and cleared the sidewalk again. Then I called my buddy Marcus, who'd lived in Willowbrook Estates for 5 years. "Oh yeah, Brenda's intense," Marcus said when I explained the situation. "She fined me $300 last year because my garbage cans were visible from the street on a non-collection day. Never mind that it was windy and they'd blown out of my garage. She's been HOA president for 3 years, and she treats it like she's running a military operation. Can she actually fine me for snow that fell after I shoveled? According to her interpretation of the rules, yeah. A couple people have fought her and won, but most folks just pay because it's easier than dealing with her. She'll make your life hell if you push back. I thanked Marcus and hung up, staring at the fine notice. $250 seemed absurd, but the thought of giving Brenda Morrison that satisfaction made my blood boil. I decided to contest it. The HOA board met once a month in the community center, a squat brick building near the entrance of the subdivision. I submitted my written objection and showed up on the designated evening, armed with photos of my freshly shoveled sidewalk, time-stamped from the morning I'd received the first citation. The board consisted of 5 members. Brenda as president, 2 middle-aged men named Harold and Rick, who seemed primarily interested in their phones, an elderly woman named Dorothy who knitted throughout the meeting, and a younger guy named Kevin who actually appeared to be paying attention. When my turn came, I presented my case. I'd shoveled within the required time frame. The snow Brenda photographed had fallen after I'd cleared the walk. Requiring homeowners to constantly monitor and reshovel during ongoing snowfall was unreasonable and likely unenforceable. Brenda listened with her arms crossed, her expression growing more pinched with every word I spoke. When I finished, she didn't even pause. The covenant is clear, Quincy. During winter weather events, walks must be maintained. Not shoveled once and forgotten, but maintained. Your interpretation would allow dangerous conditions to develop. Dangerous. It was an inch of powder. Ice forms under snow. Someone could slip and fall. As HOA president, I have a responsibility to protect this community. She turned to the other board members. I moved to uphold the fine. Harold and Rick immediately raised their hands without looking up from their phones. Dorothy kept knitting but lifted one hand briefly. Kevin hesitated, then shook his head. I think Quincy has a point. The rule seems intended to prevent neglect, not punish people for normal snowfall patterns. Brenda's face flushed. Are you questioning my judgment? I'm questioning whether this fine is fair. 4 votes to 1. The fine stands. Brenda made a notation in her ledger and looked past me to the next person waiting to speak. Next item. I left the meeting furious but determined not to let Brenda win. I paid the fine under protest and made sure to shovel my walk meticulously every single morning before work. I even set my alarm an hour early on days when snow was forecasted. For 2 weeks, I didn't hear from Brenda. I started to think maybe she'd moved on to tormenting someone else. Then came the morning that changed everything. It was February 9th, a Thursday. I checked the weather the night before and saw clear skies predicted, so I didn't bother setting my early alarm. When I woke up at my normal 6 o'clock, I was shocked to see my window completely frosted over. I scraped at it and discovered freezing rain coating everything outside. I hurried through my morning routine and went out to assess the damage. My driveway and sidewalk were covered in a thin layer of ice. The freezing rain had apparently started around 4 in the morning and stopped around 5:30, just before I woke up. I didn't have any ice melt in my garage, having used the last of it the week before and forgotten to buy more. I needed to get to work by 8 for an important meeting with a client. My job as a construction project manager required me to be on site at specific times, and this meeting had been scheduled for weeks. I made a quick decision. I'd carefully chip away the ice on my driveway so I could get my truck out, then stop at the hardware store on my way home that evening to buy ice melt. I'd take care of the sidewalk as soon as I got back. The HOA rules specified 24 hours to clear snow and ice, so technically I had until 4 o'clock the next morning. I'd be back by 6 that evening at the latest, giving me plenty of time. I chipped out my driveway, carefully navigated the icy streets, and made it to the job site with 10 minutes to spare. The meeting went well, and I spent the rest of the day coordinating with subcontractors and reviewing building plans. I left at 5:15 and stopped at the hardware store to grab 2 large bags of ice melt. When I pulled onto my street at 5:45, there were 3 police cars and an ambulance parked in front of my house. My heart jumped into my throat as I parked and ran toward the cluster of emergency vehicles. Brenda Morrison was sitting in the back of the ambulance, her leg propped up, surrounded by paramedics. She saw me approaching, and her face transformed into a mask of pain and indignation. "That's him. That's the homeowner," she pointed at me with a trembling finger. "He deliberately refused to clear his walk, and I slipped on the ice. I think my ankle is broken." One of the police officers, a stocky guy with a gray mustache, turned to me. "Sir, are you the owner of 447 Maple Drive?" "I am." "What happened?" "This woman says she slipped and fell on the ice on your sidewalk. She's alleging negligence." I looked at Brenda, who was now clutching her ankle and moaning dramatically for the paramedics. "When did this happen?" The officer checked his notes. "Call came in at 5:15. She says she was conducting routine inspections of the neighborhood when she fell. The freezing rain stopped at 5:30 this morning. I've been at work all day. I was planning to put down ice melt as soon as I got home." I held up the bags I was still carrying. Brenda's voice rose sharply. "The covenant requires immediate clearance during winter weather events. You knowingly left your walk in a dangerous condition." "The covenant allows 24 hours, I countered. "And it wasn't even 6 o'clock yet. I had until 4 in the morning tomorrow." The officer looked between us, clearly realizing he'd stepped into the middle of an HOA dispute. "Sir, do you have ice melt now?" "Yes, I just bought it." "Then I'd suggest you apply it. Madam, the paramedics will transport you to the hospital. If you want to pursue this further, that's a civil matter, not criminal." Brenda's eyes narrowed. "Oh, I'll be pursuing this. You can count on that, Quincy." The ambulance left with Brenda still complaining loudly about negligent homeowners and community safety. I spent the next hour spreading ice melt on every inch of my driveway and sidewalk, then did the same for my elderly neighbor, Mrs. Patterson, who'd come out to see what the commotion was about. "That woman is a menace," Mrs. Patterson said, shaking her head. "She's been looking for an excuse to go after you ever since you challenged her at that board meeting. I'd bet money she was walking on your sidewalk specifically hoping to find a violation. She said she was doing routine inspections. At 5:15 in the evening. In freezing rain, please. She was hunting." I didn't want to believe anyone would be that vindictive, but I also knew Brenda well enough by now to know Mrs. Patterson might be right. 3 days later, I was served with legal papers. Brenda Morrison was suing me for medical expenses, pain and suffering, and punitive damages related to my gross negligence and willful disregard for safety. She was asking for $50,000. I read the complaint in stunned disbelief. According to the filing, Brenda had suffered a fractured ankle, torn ligaments, severe bruising, and ongoing pain that would require months of physical therapy. She claimed I'd deliberately refused to clear the ice, despite knowing she conducted regular neighborhood inspections and would be walking past my property. She further alleged that my pattern of violations demonstrated a reckless attitude toward community safety. The complaint included several photographs showing the icy sidewalk and Brenda's swollen, bruised ankle. It also included copies of my previous violation notices and the records from the board meeting where I'd contested the fine. I immediately called a lawyer, a guy named Stephen Fitzgerald who my cousin had recommended. Stephen had a small practice in downtown Naperville and specialized in civil litigation. "She's got nothing," Stephen said after reviewing the paperwork. Illinois law is pretty clear about slip and fall cases. She has to prove you knew about the dangerous condition and failed to remedy it within a reasonable time. Freezing rain stopped at 5:30 in the morning. She fell at 5:15 in the evening. The HOA covenant allows 24 hours for clearance, and you'd already purchased ice melt and were home to apply it. No reasonable person would consider that negligence. So I should be fine. In theory, yes. But here's the thing about these cases. They're expensive to defend even when you're clearly not at fault. Court costs, my fees, your time off work. Sometimes it's cheaper to settle for nuisance value, maybe offer to pay her medical deductible and call it done. Absolutely not. She's been harassing me for months and I'm not giving her a penny. If we settle, she'll see it as validation and just come after me again for something else. Stephen nodded slowly. I respect that. Okay, then we fight. Fair warning, this is going to get ugly. She's already established a paper trail with those violation notices. She'll argue you had a pattern of negligence. We'll need to counter that hard. Over the next several weeks, we built our defense. Stephen subpoenaed weather records showing the exact timing of the freezing rain. We gathered statements from neighbors attesting to my general diligence in maintaining my property. We obtained a copy of the HOA covenant showing the 24-hour clearance requirement. Stephen even consulted with a personal injury expert who confirmed that Brenda's injuries, while real, were consistent with a simple slip and fall, not the catastrophic incident she was claiming. Meanwhile, Brenda made sure everyone in the neighborhood knew about the lawsuit. She sent an email to all homeowners warning them about the dangerous precedent of residents who refuse to maintain their properties. She posted on the neighborhood Facebook group about her ongoing suffering and medical treatments. She showed up at the next HOA meeting on crutches, wincing dramatically every time she moved. Several neighbors reached out to offer their support, which I appreciated more than I could express. Marcus told me at least a dozen people had privately complained to him about Brenda's behavior. Mrs. Patterson baked me cookies and told me stories about previous homeowners Brenda had targeted. Even Kevin from the HOA board stopped by one evening to say he thought Brenda had gone too far this time. But there were others who seemed to side with Brenda, or at least who were too intimidated by her to speak out. Harold and Rick, the other board members, publicly supported her version of events. A couple of newer residents seemed to buy into her narrative about negligent homeowners creating dangerous conditions. The subdivision developed an uncomfortable tension. People who'd previously chatted in driveways or waved while walking dogs now seemed uncertain about how to act. The upcoming court date hung over everything like a storm cloud. Stephen filed our response to the complaint, laying out our defense and countersuing for legal fees under Illinois law, which allows prevailing parties to recover costs in frivolous lawsuits. Brenda's attorney, a sharp-dressed woman named Patricia Yates, who apparently specialized in personal injury cases, fired back with an amended complaint that added allegations of intentional infliction of emotional distress. That's actually good for us, Stephen explained. The more extreme her claims get, the less credible she looks. Intentional infliction of emotional distress requires outrageous conduct. Not shoveling ice within 12 hours isn't outrageous. We went through discovery, which was exactly as tedious as it sounds. I had to provide written answers to dozens of questions about my employment history, my financial situation, my prior addresses, my property maintenance practices, and my relationship with Brenda. I had to sit for a deposition where Patricia Yates spent 4 hours trying to paint me as a careless, hostile resident who deliberately endangered Brenda out of spite. You contested a fine from Mrs. Morrison, correct? I did. I felt it was unfair. Would you say you were angry with her? Frustrated, maybe. Not angry. But you did tell another resident that you found her interpretation of the rules to be, quote, absurd, didn't you? I may have used that word, yes. So you had contempt for Mrs. Morrison's role as HOA president. I had disagreements with some of her decisions. That's not contempt. It went on like that, Patricia trying to establish that I harbored some kind of grudge that led me to deliberately endanger Brenda. I kept my answers measured and factual, exactly as Stephen had coached me. Brenda's deposition was more interesting. Stephen conducted it in Patricia's conference room, and I was allowed to attend as the defendant. Brenda showed up in a walking boot and made a show of struggling to get comfortable in her chair. Stephen started with basic questions about her role as HOA president, her inspection routines, and her relationship with various homeowners. Then he got more specific. Mrs. Morrison, you stated in your complaint that you were conducting routine inspections on the evening of February 9th. Is that correct? Yes, that's correct. What time did you begin these inspections? Around 4:30. And what properties did you inspect before arriving at Mr. Quincy J.'s home? Brenda hesitated. I don't recall the exact sequence. You don't recall which houses you inspected during your routine. I inspect multiple properties. I can't be expected to remember every detail. Stephen made a note. What were you inspecting for that evening? General compliance with covenant requirements. In freezing rain. In near darkness. I take my responsibilities seriously regardless of weather conditions. I see. And you were walking on sidewalks during these inspections. Of course. How else would I inspect them? Were the sidewalks on other properties icy as well? Some were, yes. Did you fall on any other property? No. Why not? Brenda shifted in her chair. I don't understand the question. If multiple sidewalks were icy, why did you only fall on Mr. Quincy's sidewalk? I suppose the ice there was worse, or I was tired by that point in my inspection route. Or perhaps you were being particularly careful on other properties, but were less careful on Mr. Quincy's property? Patricia objected, and there was a brief argument about improper characterization. Stephen moved on, but he'd made his point. The more Brenda talked, the clearer it became that she'd specifically targeted my property. Mrs. Morrison, had you documented other violations by Mr. Quincy prior to February 9th? Yes, several. How many violations had you documented for other homeowners during that same period? Another hesitation. I'd have to check my records. I have copies of all violation notices issued between January 1st and February 9th. You issued 17 total notices. 7 of them went to Mr. Quincy. The other 10 were distributed among approximately 300 other properties. Does that sound accurate, if that's what the records show? Would you say you paid particular attention to Mr. Quincy's property? I pay equal attention to all properties. But Mr. Quincy received 41% of all violations, despite representing 0.3% of total properties. Patricia objected again, and Stephen eventually moved on. But watching Brenda squirm was deeply satisfying. The best part came near the end of the deposition. Stephen asked about Brenda's injuries and medical treatment. She described the pain, the emergency room visit, the orthoptist appointments, the physical therapy sessions. She'd clearly prepared this section carefully, probably with Patricia's coaching. Then Stephen asked a simple question. Mrs. Morrison, did you record video on the evening you fell? Brenda's face went blank. I don't recall. You don't recall whether you were recording video? I sometimes record conditions during inspections. I'd have to check my phone. Please do check your phone, Mrs. Morrison, because we'll be requesting all videos and photographs from that evening as part of discovery. Patricia quickly called for a break. I could see her and Brenda huddling in the corner of the conference room, talking in urgent whispers. When they came back, Patricia announced that Brenda had located several videos from that evening which she would provide as required. Stephen and I left the deposition feeling cautiously optimistic. Back in his office, Stephen explained what he suspected. She was recording. I'd bet anything she was recording when she fell. People like her, who document everything obsessively, they always record. And if she was recording, that video will show exactly what happened. Won't that be bad for us if it shows her falling on my icy sidewalk? Maybe. Or maybe it shows something else. We'll know soon enough. 3 days later, Patricia's office sent over the video files. There were 7 clips total, showing various properties around the neighborhood. Stephen and I watched them together on his computer. The first 6 videos were exactly what you'd expect. Brenda walking along sidewalks, narrating observations about snow accumulation, ice patches, and garbage placement. Her commentary was petty and officious, filled with references to covenant sections and violation categories. The 7th video was the jackpot. The footage showed my house at dusk, the streetlight casting long shadows. Brenda's voice came through clearly. 447 Maple Drive, approaching from the east. Visibility is poor due to weather conditions, but I can clearly see ice on the sidewalk. This is the 3rd violation for this property in 2 weeks. The homeowner has demonstrated a pattern of negligence that poses a serious safety risk. The camera bounced slightly as she walked, the image showing her feet moving across the icy concrete. Then the view swung up briefly, capturing my house and the bags of ice melt visible through my truck's rear window where I'd parked at the curb after arriving home. Homeowner appears to have just returned, Brenda continued. However, ice remains untreated, presenting an ongoing hazard. Then came the critical moment. The camera swung down to show the sidewalk directly ahead. The ice was visible but not particularly thick. Brenda's foot entered the frame, and you could see her deliberately position it on a particularly slick-looking patch. Her foot began to slide, and the camera jerked wildly as she fell. The audio captured her cry of pain, then several seconds of rapid breathing before the video cut off. Stephen and I watched it 3 times in silence. Then Stephen started laughing. She did it on purpose. She deliberately stepped on the ice in a way that would make her slip. Did you see how she positioned her foot? No one walks like that naturally. Will the judge see it that way? The judge will see a woman who recorded herself walking up to an icy patch, narrating about violations while holding recording equipment, positioning her foot awkwardly, and then falling. Even if we can't prove absolute intent, it's clear she was being reckless with her own safety. That destroys her negligence claim. Stephen immediately filed a motion for summary judgment, arguing that Brenda's own video evidence proved she'd assumed the risk of walking on ice and had failed to exercise reasonable care for her own safety. He attached the video file and included a detailed frame-by-frame analysis showing the unnatural way Brenda had placed her foot. Patricia Yates filed a response claiming the video showed nothing of the sort, that Brenda had simply slipped on dangerous ice I'd failed to clear, and that analyzing her walking pattern was irrelevant speculation. She argued that my duty to maintain the sidewalk superseded any question of Brenda's conduct. The judge scheduled a hearing for April 3rd, nearly 2 months after the incident. Those 2 months dragged by with agonizing slowness. I went to work, came home, cleared my sidewalk religiously even when there was barely a dusting of snow, and tried not to think about the tens of thousands of dollars in legal fees I was accumulating. Brenda continued her campaign within the neighborhood, though the video revelation had clearly shaken her confidence. She was less vocal at HOA meetings and stopped sending community-wide emails about the case. But she still glared at me whenever we crossed paths, and she still documented every perceived violation with the fervor of a medieval inquisitor. Finally, April 3rd arrived. Stephen and I met at the courthouse in downtown Naperville, a stately building with marble floors and dark wood paneling. We found our assigned courtroom on the 3rd floor and took our seats at the defendant's table. Brenda and Patricia arrived a few minutes later. Brenda had traded her walking boot for a brace and a cane, which she leaned on heavily as she made her way to the plaintiff's table. She didn't look in my direction. Judge Ronald Kemper entered at precisely 9 o'clock. He was a thin man in his early 60s with wire-rimmed glasses and a no-nonsense demeanor. He reviewed the file briefly, then looked up at both tables. "I've read the briefs and reviewed the submitted evidence, including the video recording. This is a hearing on defendant's motion for summary judgment. Miss Yates, you may proceed." Patricia stood and launched into her argument. She displayed photographs of the icy sidewalk and Brenda's injuries. She cited case law about property owners' duty to maintain safe conditions. She emphasized the HOA covenant requirements and my previous violations, painting a picture of a negligent homeowner who'd repeatedly ignored his responsibilities. "Your Honor, the defendant had ample opportunity to clear the ice from his sidewalk. The freezing rain stopped at 5:30 in the morning. By 5:15 that evening, nearly 12 hours later, he still had not applied any treatment to the dangerous conditions he allowed to develop. My client, acting in her capacity as HOA president and exercising her right to inspect properties within the community, was injured as a direct result of the defendant's negligence. The video recording shows clearly that she slipped on ice the defendant failed to clear. The defense's speculation about how my client walks or positions her feet is irrelevant and frankly offensive. What matters is that she was injured on the defendant's property due to his failure to maintain safe conditions. Patricia spoke for another 10 minutes, her voice rising with practiced indignation. When she finished, Judge Kemper turned to Stephen. "Mr. Fitzgerald," Stephen stood and picked up a remote control. "Your Honor, with the court's permission, I'd like to play the video recording again." The judge nodded, and Stephen queued up the file on the courtroom's display screen. We all watched as Brenda's narration played through the speakers, her commentary about violations and safety risks echoing through the quiet room. When the video reached the moment of the fall, Stephen paused it. "Your Honor, please note the plaintiff's foot position here." He used a laser pointer to indicate the screen. "This is not a natural walking stride. Her foot is positioned perpendicular to her direction of travel, maximizing contact with the ice patch, if we advance frame by frame." He clicked through the video slowly. "You can see her weight shift deliberately onto that foot before it begins to slide." Judge Kemper leaned forward, studying the frozen images. Stephen continued. "Illinois law is clear that a plaintiff in a slip-and-fall case must demonstrate she exercised reasonable care for her own safety." The video shows the plaintiff approaching a clearly visible ice patch while holding recording equipment and narrating her observations. She was distracted by her documentation activities and failed to watch where she was stepping. More critically, she was on the defendant's property at 5:15 in the evening specifically to find violations and document them. She was not an innocent pedestrian using the sidewalk for normal transit. She was there to create evidence against the defendant. Objection, Your Honor. Patricia shot to her feet. That's pure speculation and mischaracterizes my client's legitimate activities. I'll allow argument on the motion, Judge Kemper said. Continue, Mr. Fitzgerald. Your Honor, the plaintiff's own words on the recording demonstrate her intent. She references this being the third violation in 2 weeks and discusses the defendant's pattern of negligence. She was building a case against him. When she arrived at his property and saw ice on the sidewalk, she saw an opportunity. The video shows she had just arrived home from work, evidenced by his truck at the curb with bags of ice melt visible in the rear window. The plaintiff even notes on the recording that the homeowner had just returned. She knew he was in the process of addressing the condition. Instead of waiting or alerting him to her safety concerns, she chose to walk on the ice while recording, positioning her foot in a manner that would maximize the chance of slipping. That's absurd, Brenda burst out from the plaintiff's table. I didn't deliberately hurt myself. Judge Kemper fixed her with a stern look. Mrs. Morrison, you'll have an opportunity to testify if we proceed to trial. For now, please remain quiet, Stephen pressed on. Whether the plaintiff deliberately caused her fall or simply engaged in reckless behavior, the result is the same. She assumed the risk of walking on visible ice while distracted by recording equipment. She failed to exercise reasonable care for her own safety. And critically, she did so on property where the owner was present and actively preparing to treat the condition, well within the 24-hour time frame allowed by the HOA covenant she herself helped write. Under Illinois law, these facts preclude recovery as a matter of law. The defendant owed no duty to protect the plaintiff from obvious, visible ice that she chose to walk on while distracted. Judge Kemper removed his glasses and rubbed the bridge of his nose. Miss Yates, response. Patricia stood again, but some of the confidence had drained from her voice. Your Honor, the defendant's duty to maintain safe conditions exists regardless of the plaintiff's conduct. Even if the plaintiff was distracted, that doesn't absolve the defendant of his negligence in failing to clear the ice. The plaintiff's own recording indicates the defendant had just arrived home with ice melt, the judge said. He was within the 24-hour clearance window required by the HOA covenant. How is that negligent? The covenant establishes a minimum standard, Your Honor. Common sense and basic decency require clearing hazardous ice as soon as possible, not waiting until the last moment. But Miss Yates, 12 hours is hardly the last moment, especially when the property owner was at work during that time. And the plaintiff chose to walk on that ice while recording video and narrating her observations. Even taking all facts in the light most favorable to the plaintiff, I'm having difficulty seeing how the defendant breached any duty here. Patricia tried several more arguments, but Judge Kemper had clearly made up his mind. After another 15 minutes of back and forth, he delivered his ruling. I'm granting the defendant's motion for summary judgment. Based on the video evidence and the undisputed facts, no reasonable jury could find the defendant negligent under these circumstances. The plaintiff was aware of the icy conditions, chose to walk on the ice while distracted by recording equipment, and did so during a time frame when the defendant was acting reasonably in accordance with HOA requirements. The plaintiff assumed the risk of her conduct. Furthermore, the video raises serious questions about whether the plaintiff exercised any care for her own safety. This case is dismissed. Brenda made a strangled sound. Patricia immediately requested the opportunity to appeal, which the judge noted for the record. Then Stephen stood again. Your Honor, the defendant has a cross motion for attorney's fees and costs under Illinois Statute 735 Ilks 5/2611, which allows recovery when a lawsuit is frivolous or brought for harassment purposes. We respectfully request the court award fees and costs incurred in defending this baseless action. Judge Kemper looked at Brenda, and his expression hardened. Mrs. Morrison, did you review the video recording before filing this lawsuit? Brenda glanced at Patricia, who subtly shook her head. But the judge was waiting, and Brenda had to answer. Yes, Your Honor. And you still chose to proceed with claims of gross negligence and intentional infliction of emotional distress. I was injured, Your Honor. I have medical bills and ongoing pain. I don't doubt you were injured, Mrs. Morrison. But your injuries don't automatically entitle you to compensation, particularly when you bear significant responsibility for causing them. You had video evidence showing you walking on obvious ice while distracted. You knew the defendant had just arrived home and was preparing to treat the condition. You proceeded anyway, and when you were injured, you filed suit claiming he was grossly negligent and had intentionally inflicted distress. That goes beyond zealous advocacy into the realm of harassment. He turned to the stack of papers before him, flipping through what appeared to be the violation notices. I also have copies of numerous citations you issued to Mr. Quincy, significantly more than you issued to other homeowners during the same period. This suggests a pattern of targeting. Combined with the circumstances of your fall and the nature of the claims in your complaint, I find this lawsuit was brought at least in part for improper purposes. I'm awarding the defendant reasonable attorney's fees and costs. Mr. Fitzgerald, please submit a verified petition within 14 days. Patricia tried to object, but Judge Kemper was done. He gathered his files and left the courtroom, leaving us in stunned silence. I turned to Stephen, who was grinning broadly. We won, and you're getting your fees paid. We'll see how much she actually pays, but yeah, this is a great result. Behind us, I could hear Brenda arguing with Patricia in furious whispers. I caught fragments about appeals and miscarriage of justice and activist judges. Patricia was trying to calm her down, but Brenda's voice kept rising. We left the courtroom and made it halfway down the hall before Brenda caught up to us. She'd abandoned her cane and was moving at a brisk pace, her face flushed with anger. This isn't over, Quincy. I'll appeal this. I'll take it all the way to the state Supreme Court if I have to. Stephen stepped between us. Mrs. Morrison, you should discuss any further action with your attorney, and I'd strongly advise against making threats in a courthouse. It's not a threat, it's a promise. You think you can just ignore community standards and get away with it. I'm still HOA president, and I will make sure you comply with every single rule. Actually, Mrs. Morrison, you might want to check the HOA bylaws. Kevin's voice came from behind us. I turned to see him approaching with Dorothy, the elderly board member. We've called a special election for next week. There's been a petition signed by 60% of homeowners requesting your removal as president. Brenda's mouth opened and closed like a fish. You can't do that. We can, and we did. The bylaws allow for recall with a majority petition. People are tired of the harassment and the toxic environment you've created. Kevin's voice was calm but firm. Dorothy will serve as interim president until the election. You'll regret this, all of you. Brenda spun on her heel and stormed off down the hallway, her supposed ankle injury apparently forgotten. Dorothy shook her head. Poor woman. She's going to make herself sick with all that anger. Kevin turned to me. Sorry you had to deal with this, Quincy. Most of us never wanted things to get so out of hand. I appreciate the support, and I'm glad you're making changes. We talked for a few more minutes before Stephen and I headed out. In the parking lot, he clapped me on the shoulder. Congratulations. You stood your ground and won. Not everyone has the spine to fight back against people like Brenda Morrison. I just couldn't let her bully me. The principle mattered. Well, the principle cost her. Between the case dismissal, the fee award, and losing her position, she's had a very bad day. Stephen was right. Over the next 2 weeks, I submitted detailed billing records showing I'd incurred just over $18,000 in legal fees and costs defending the lawsuit. Judge Kemper reviewed the petition and awarded the full amount, ruling that every dollar spent had been necessary due to the frivolous nature of Brenda's claims. Brenda tried to appeal both the dismissal and the fee award, but the appellate court rejected her appeal in a brief order that basically said Judge Kemper had gotten it right. She was stuck with the judgment. The special election happened on a Tuesday evening in late April. Nearly 200 homeowners showed up, which Kevin said was unprecedented for HOA meetings. The voting wasn't even close. Brenda received 14 votes out of 193 cast. A guy named Thomas Richardson, who worked in banking and promised a common-sense approach to HOA management, won in a landslide. Brenda tried to challenge the election results, but the bylaws were clear. She was out. Thomas took over immediately, and one of his first acts was rescinding several of Brenda's more ridiculous rules, including the interpretation that required constant snow clearing during ongoing weather events. I ran into Brenda one more time, about a month after the election. I was mowing my lawn on a Saturday morning when she pulled up in her car. She got out and walked over, and I braced myself for another confrontation, but she looked different, smaller somehow, tired. The anger that had burned so bright seemed to have guttered out, leaving only exhaustion. "I wanted to tell you that I'm moving," she said without preamble. "I've accepted a position in Arizona. I'll be gone by the end of June." I shut off the mower. "I'm sorry things worked out this way. Are you? You cost me everything. My position, my reputation, $18,000. Brenda, you did this to yourself. You targeted me for months over trivial issues. You walked on ice you knew was there while recording video, then sued me for $50,000. What did you think would happen?" She looked away. "I thought I was protecting the community, maintaining standards, making sure people followed the rules. You were on a power trip. There's a difference." She flinched but didn't argue. Maybe you're right. For what it's worth, I am sorry. About the lawsuit, I mean. I should have watched that video more carefully before I filed." "Yeah, you should have." We stood there in awkward silence for a moment. Then Brenda turned and walked back to her car. She paused before getting in. "For what it's worth, Quincy, you keep a nice lawn." Then she was gone, and I was left standing in my yard with the smell of fresh cut grass and the sound of suburban Saturday morning all around me. The next HOA meeting under Thomas's leadership was remarkably pleasant. We discussed actual issues like repaving the community center parking lot and organizing a neighborhood picnic. Nobody threatened anyone with fines. Nobody cited covenant sections. It was boring in the best possible way. Marcus found me afterward in the parking lot. "Man, what a difference." I actually enjoyed that meeting. It's amazing what happens when people act reasonably. You started it, standing up to Brenda. If you just paid that first fine and backed down, she'd still be terrorizing everyone. I don't know about that. Someone would have pushed back eventually. Maybe. But you were the one who actually did it. People respect that. Over the following months, life in Willowbrook Estates returned to normal, or at least what normal should have been all along. I focused on my job, maintained my property without obsessing over every snowflake, and got to know my neighbors without the constant tension of HOA drama. Brenda's house sold in July to a young couple with 2 kids. They seemed nice, and more importantly, They seemed utterly unconcerned with HOA politics. Thomas Richardson proved to be an excellent HOA president, handling issues with common sense and actually working with homeowners instead of against them. I never did collect the full $18,000 from Brenda. Her attorney negotiated a payment plan, and I received about $12,000 before Brenda moved to Arizona. Stephen advised me I could pursue the rest through collections or by placing a lien on her house before it sold, but I decided to let it go. The principle had been established, the case was won, and I had better things to do than chase Brenda Morrison across the country for the remaining balance. Looking back on the whole mess, I learned several important lessons. First, always document everything when dealing with unreasonable people. Second, sometimes standing up to bullies costs money and time in the short term but saves a lot of grief in the long term. And third, when someone is recording themselves approaching an icy sidewalk while narrating about violations, that recording will inevitably become evidence, so make sure it shows what you think it shows. The story made the rounds in Naperville for a while. Local news picked it up as a human interest piece about HOA overreach, though they didn't use names. I got recognized a few times at the grocery store or the hardware store, people wanting to hear about the case where the HOA president sued herself into irrelevance. I always kept the story brief and factual, but I'll admit there was satisfaction in telling it. Not because I'd hurt Brenda or cost her money, but because I'd proven that residents don't have to accept harassment from petty tyrants just because those tyrants hold positions in homeowner associations. The following winter came with its own snow and ice, but this time I shoveled when I could, used ice melt when appropriate, and never once worried about whether I was meeting some arbitrary interpretation of the rules. Thomas sent out a reasonable email reminding everyone to keep walks clear as weather permitted, emphasizing safety over strict time frames. Nobody got fined. Nobody got sued. It was wonderfully boring. Mrs. Patterson, my elderly neighbor, invited me over for dinner one evening in December. Over pot roast and mashed potatoes, she told me stories about the neighborhood before Brenda had become HOA president. It used to be friendly, she said. People helped each other. We had block parties and holiday lights contests, and nobody worried about violation notices. Then Brenda took over and everything changed. She was always so angry about something. Why do you think she was like that? Mrs. Patterson shrugged. Some people need to control things to feel important, and some people mistake being feared for being respected. Brenda was both types. But she's gone now, and good riddance. You did us all a favor by standing up to her. I was just defending myself. Same thing, dear, same thing. As winter settled in and the holidays approached, I found myself appreciating my home and my neighborhood in ways I hadn't when I'd first moved in. The peace was tangible. The absence of tension made everything better. I could shovel my driveway without wondering if someone was photographing me from the bushes. I could park my truck in front of my house without worrying about citation notices. I could just live. That's really what the whole fight had been about, when you stripped away the legal arguments and the HOA politics and the personal animosity. It was about the right to live in my own home without constant harassment. It was about reasonable standards versus arbitrary enforcement. It was about whether one person's need for control could trump an entire community's desire for peace. The answer, thankfully, was no. The judge had seen through Brenda's claims. The neighborhood had voted her out. The system, despite its flaws and delays and expenses, had ultimately worked. Justice wasn't always swift, but in this case, it had been satisfyingly thorough. I never heard from Brenda again after she moved. I sometimes wondered if she'd found another HOA to run in Arizona, or if the experience had taught her something about the limits of authority. I hoped for her sake she'd learned something, but I suspected she probably hadn't. People like Brenda rarely changed, but that wasn't my problem anymore. My problem was deciding whether to hang Christmas lights, and if so, whether to go with white lights or colored ones, and how many strands were too many before crossing into tackiness. These were good problems, normal problems, the kind of problems that homeownership was supposed to involve. I went with white lights, tastefully arranged along the roofline and wrapped around the two small trees in my front yard. Marcus came over to help with the installation, and we had a few beers afterward while admiring our work. "Think anyone will cite you for light placement," Marcus joked. "If they do, I'll sue them and show the judge a video of myself hanging them." We both laughed, and the sound carried through the quiet winter evening, mixing with the distant noise of children playing in the snow and the general hum of suburban life continuing on as it should. The whole ordeal with Brenda Morrison had lasted less than 6 months from the first violation notice to her moving away, but it had felt like years while I was living through it. Now, from the comfortable distance of a few months, it seemed almost absurd. A woman had deliberately walked on ice, recorded herself falling, then sued me for $50,000, only to lose everything when a judge watched her own video evidence. It was the kind of story that sounded too ridiculous to be true, but every word of it was documented fact. The court records existed. The video existed. The violation notices and the legal filings and the payment plan for the attorney's fees all existed. It had really happened, as impossible as that seemed, and that, I supposed, was the most important lesson of all. Sometimes reality was stranger than fiction. Sometimes people really were as unreasonable as Brenda Morrison. Sometimes standing up for yourself meant months of stress and thousands of dollars in legal fees. But sometimes it was worth it, not just for the principle, but for the peace that came afterward. As I sat on my porch that December evening, watching the lights twinkle and the snow fall gently over Willowbrook Estates, I felt genuinely grateful. Grateful for good neighbors like Marcus and Mrs. Patterson and Kevin. Grateful for a competent lawyer like Stephen Fitzgerald. Grateful for a judge like Ronald Kemper who actually watched the evidence and made the right call. Grateful for bylaws that allowed residents to recall bad HOA presidents. And yes, in a weird way, grateful even for Brenda Morrison. Not because I enjoyed the conflict or the lawsuit, but because fighting back against her had taught me something valuable about standing up for what was right even when it was difficult and expensive. That was a lesson worth learning, even if the tuition had been steep. The next morning dawned clear and cold, and I shoveled my sidewalk before work out of simple consideration for pedestrians, not because I feared violation notices. It felt good. Natural, the way it should have felt all along. As I finished up and put the shovel away, Mrs. Patterson walked past with her small dog. She waved and smiled, and I waved back. No drama, no citations, no tension, just neighbors being neighborly on a winter morning in suburban Illinois. It was perfect. It was normal. It was everything I'd wanted when I'd moved to Willowbrook Estates 6 months earlier, before Brenda Morrison and her power trips and her lawsuits had complicated everything. Now, finally, I had it. The ice on my sidewalk that had caused so much trouble was long melted, but the memory of that February evening remained crystal clear. I could still see Brenda in the back of that ambulance, pointing at me with righteous indignation. I could still feel the shock of being served with a $50,000 lawsuit. I could still remember the anger and the frustration and the determination not to give in. but I could also remember the satisfaction of watching that video play in court. The look on Brenda's face when the judge granted summary judgment. The relief of winning. The justice of having her pay my attorney's fees. The vindication of being proven right. Those memories balanced out the negative ones, creating a complete picture of an experience that had been awful while it was happening but valuable in retrospect. I'd been tested, and I'd passed. I'd been pushed, and I'd pushed back. I'd been sued by someone who thought their position gave them unlimited power, and I'd proven that even HOA presidents have to answer for their actions. Spring came eventually, as it always does, and with it came the neighborhood picnic Thomas had organized. Nearly every house in Willowbrook Estates was represented. Kids played on the community center lawn. Adults grilled burgers and hot dogs and talked about normal things like work and sports and vacation plans. Nobody mentioned Brenda. Nobody talked about lawsuits or violations or covenant enforcement. It was like the whole ugly chapter had been erased, or at least filed away as something that happened once but would never happen again. The community had learned its lesson about electing reasonable leaders. The residents had learned they could push back against unreasonable authority. And I'd learned that sometimes the right course of action was also the hardest one. As I sat at a picnic table with Marcus and Kevin and Thomas, eating a burger and watching the sun set over the subdivision, I realized I'd finally found what I'd been looking for when I bought my house. Community. Peace. Normalcy. The ability to live my life without constant conflict. It had taken a fight to get there, ironically enough. It had taken standing up to Brenda and enduring her lawsuit and spending thousands of dollars on lawyers. But I'd gotten there in the end, and that made all the struggle worthwhile. The ice had melted. The lawsuit had been dismissed. The tyrant had been deposed. And life in Willowbrook Estates continued on, better than before, warmer than before, and infinitely more peaceful than before. That was worth celebrating, and so I raised my beer in a quiet toast to survival, to justice, and to the simple pleasure of living in a neighborhood where people treated each other with basic human decency. Marcus noticed and raised his own beer. "What are we drinking to?" "To ice that melts," I said, "and to people who get what they deserve." "I'll drink to that," Marcus said, and we clinked bottles while the spring evening settled around us, full of promise and possibility and the comfortable knowledge that some battles, once won, stay won.